welcome back for Act 2 of the 8th Annual Business Law Symposium, The Business of the Lawsuit. Now, please welcome to the stage 8 lawyers for a battle royale on various subjects as to which these teams of debaters are sure to disagree. On Team Noah, we have 3 fiery lawyers who are better friends than foes and who have cut their chops litigating monumental litigation battles for decades. 3 of the best, James Allen, Sara MacWilliams, and Ben Aloia. Their team leader and advocate moderator is Noah Mathews. Their adversaries are equally crushing, with decades of trial work behind them and some very strong opinions on how it should be done and not done. Again, better friends than foes. Don't let their smiles fool you. They are led by advocate moderator T. Maxwell Carey.
All right, we're going to start now. So I will be representing Joe, Joel, and Ryan, and I will be directing questions towards Noah's team. So we'll start off with the first question. Jim, do you think the business courts are effective? Have they achieved their purpose?
I think it depends on which county you're talking about. I think most of my experience obviously is in Wayne County. I think the business court has served a good purpose there, but what's happened over the years is there's been somewhat of a mission creep where the business court judges are doing less and less business court litigation, and unfortunately the automobile negligence cases have crept onto the business court judges' dockets, and I think that's slowed us down in the business court or in the commercial litigation realm, which is unfortunate. I think the solution to that is not to throw the baby out with the bathwater, but rather to redirect the purpose of the business court and perhaps create a similar docket for the automobile negligence docket. Because if you watch the filings every day like I do in the courthouse news service, you'll see that 80 to 90% of the cases that are filed in not only Wayne County but also Macomb and Oakland and some of the surrounding counties are automobile negligence cases. And I'm not criticizing the auto neg bar for filing cases because I think there's probably fault on both sides of the plaintiffs and the defendants. The defendants probably don't settle the cases that they should settle, and I think the same can be said about the plaintiffs as well. So a lot of cases wind up in court that shouldn't, and they're slowly creeping onto the business court docket. At least that's been my experience in Wayne County.
Thank you, Jim. Would anyone from Team 2 like to respond?
I like the business court a lot because the judges understand the issues. Sometimes otherwise in other courts they do and they don't. But the dockets are a problem. In Oakland County, for example, it takes many, many months to get a dispositive motion heard in the business court. I think it's a good idea. I think that they're understaffed in a lot of areas.
Does anyone have anything else to say?
I love the business courts. I love having regular judges who know the issues. It is incredibly difficult on a complex case to also be trying to explain what some of these more esoteric business concepts are. So yes, the dockets are crowded, but I think they are serving at least some valuable purpose.
Thank you. So Ryan, when it comes to discovery disputes, isn't it more efficient for the business courts to delegate those issues to outside mediation rather than handling them themselves?
I would say no to that. The business court judges are prepared and equipped to handle business discovery disputes, and they should be handling those themselves. But before that, the business lawyers should be having those discussions and working through those issues themselves before they go to either the judge or a mediator. And one of the things that's happening is with the outside mediators, not only do you potentially have some of the scheduling lag because the good mediators are in high demand, you also have an additional cost for paying for those services that you would not have if it would be in front of the judge and the judge makes a prompt and quick ruling on those issues.
All right, thank you. Would anyone from Team 1 like to respond?
Sure. I do feel it depends on the complexity of the matter. In business court, we have many cases with thousands and thousands of documents, and there are many disputes regarding discovery, and sometimes when the judge enlists a third party, you're able to concentrate on it, that person is able to make a recommendation. Sometimes we have cases with receivers, and the receivers are able to quell some of those disputes because they control the documents, and it cuts down costs for the client. Even though the third party may have a cost, it may streamline things, because we all know that we're charging our clients for motions to compel. Many times judges don't want to rule on those motions to compel. They're imploring the parties to resolve them. Then they don't get resolved. We're going back in front of the court. And so we're charging our clients to go back to court many times, filing many motions. If we can streamline the issue, especially in complex cases where there's a lot of discovery, it's not only more efficient so we can get through the case, because as we know, judges are imploring us to move our cases very quickly. It's possibly more cost effective for the client.
Does anyone have anything else to add to that?
I can just add to that. I think sometimes with the clients that we work with, as being as well-versed in the litigation process, sometimes even more than some of the younger attorneys, having a judge tell them what the decision is not only gives the attorney cover, but it gives some finality to the issue, which is, I think, beneficial to the case progressing.
That's a really good point. Okay, we're going to move on to some discussions about oppression law. Now, Ben, should the legislature amend the oppression statutes in any way? We all love 1487 and 4515.
Well, always cautious when the legislature is amending statutes. I think some of the attorneys in this room think they can do a better job in writing the statutes for sure. I would hope that if there's an amendment that the business law section would have influence over how that would happen. I mean, I think that there's always an opportunity, there should be an opportunity to revisit it. There is some language in there that seems a little odd, and maybe as the case law comes out, it needs more fine tuning.
Thank you. Any response from Team 2?
Well, the case law has certainly clarified things over the years. I can remember in Bax versus Maroon, the first reported case, the courts didn't even understand what the statute of limitations was in oppression cases. I heard some talk earlier tonight about amendments that are pending. I'm not familiar with them, but I would think about revising the statute to better define fair value. There's a lot of discrepancy. I don't think it's fair to discount a coerced seller's compensation for his company, and I don't think when someone proves oppression there should be any discounts applied at all to the coerced seller.
I think that raises an interesting point. Does anyone have anything else to say about changing the definition of fair value?
That's an interesting point, because there may be some objective. Fair value is such an amorphous statement. I know it's different in different cases, and there could be some objective language that's there, but I'm sure there's a concern that it'd be too limiting. But even that provision itself, as a remedy, it states the purchase of at fair value of the shares of a shareholder, either by the corporation or the officers, directors, or other shareholders responsible for the wrongful act. And I thought that was interesting, though, even though it's not a limited remedy because it says including, most often it's the wrongdoer who's getting bought out. It's actually the opposite. I mean, many times that you have an innocent shareholder who's trying to do right. Maybe they're well financed and they're innocent shareholders. So it's kind of limiting. I think that language really could be rewritten. I'm not sure an officer is going to buy out a shareholder if they're not a shareholder themselves. So I think that whole provision could be revisited and fine-tuned.
All right, thank you. So Joel, For a shareholder or member oppression case, should the remedy of a buyout be no fault as in a domestic divorce case?
I think I just talked about that a little bit, but absolutely not. Certainly, the parties could structure a good buy-sell in their governing documents that allowed for that, and they could plan for it, and that would work. But otherwise, I don't see a statute that would restrict people's freedom to contract on that issue. And I don't think it's fair if someone does prove oppression that they get a no contest type of award.
Any response?
I actually agree. If you can't run a risk of a situation where you're contradicting the actual governing documents, and depends on the case.
Okay. Well, in that case, we're going to move on to something that's been talked about a lot this evening, and the benefit or the not benefit of mediation practice and strategy. Sara, isn't it fair to say that mediation is being overused in business litigation, as previously, when I call him Professor Winsten, but I.W. Winsten has said, and in some cases actually encourages the filing of lawsuits that might not otherwise be brought?
I think it's becoming a real problem. The thing is, we lawyers are in the business of looking for loopholes and finding them and exploiting them. So it was a nice idea to start to compel all business cases into mediation. Great idea at the time. It'll help clear the dockets. What I'm seeing in my practice is more and more people are going to court not because, as I like to do, they feel comfortable with taking it all the way and they believe in the merits, but they know, okay, if I get this in the business court in front of a certain judge, they're going to compel it to mediation. We can spend a lot of time. We can get it to mediation. We can settle it. Who cares? So I think it is becoming overused. I think it's becoming a problem, and we probably need to revisit this mandatory sending every single business case to mediation.
All right, I think that raises a lot of good points. Does anyone on Team 2 believe that there should be forced mediation?
I don't know if it should be forced, but I think oftentimes, and I think Bill Winsten said this earlier, a lot of these cases would have never been filed 20 or 30 years ago because the attorneys would talk. I've found pre-litigation mediation to be quite effective when you have business attorneys that are advising their clients towards a business resolution where they control the ending of their own dispute, as opposed to letting the court process, the discovery costs, and all of the other costs and uncertainty that come with litigation run wild, where if you could do a pre-litigation mediation with one of the many experienced mediators out there, I think that would result in resolutions as well as taking some of those cases that shouldn't be on the docket off the docket.
Any more input on that, Jim?
Yeah, I'd like to just dovetail off of that and add some texture from the first answer I gave about the automobile negligence docket. I remember an era when the actual judge assigned to the case had a real settlement conference. Judge Rashid, who does quite a few of the facilitations in the region, was known especially well in our Wayne County bar as somebody who would intervene early in a case and settle the case early before the clients spent a lot of money that they didn't need to spend. Unfortunately, because we have such a bloated docket, again, I think a lot of it is automobile related. The judges are not able to spend the time learning the cases, understanding what the specific triggers and leverage in a particular case are, because they're really just doing a 50,000 foot pass almost every time that you appear in front of them, and that's just a numbers game. But I totally agree with Ryan that the push for good business lawyers is to try to avoid the filing of litigation if you can, because I always tell clients, win, lose, or draw, at the end of the case, whether you have a judgment in favor or a judgment against, as soon as the case is filed, both parties have lost because they're paying a lawyer, and that's eroding whatever value there is in what investment they're trying to protect. So I am a big fan of early mediation pre-suit.
You know, that sort of begs an interesting question, whether should it be an attorney's ethical responsibility to seek a pre-litigation mediation? Does anyone have anything to say on that?
It should not be an ethical responsibility, but all of us as good attorneys should absolutely be very careful with, should this case really be filed? I always tell my clients, you want to be able to sleep the morning after you filed a lawsuit, so make sure that you have done everything possible to avoid it first, up to and including mediation.
And I think that's, one of the other panelists said this before, sometimes the bullet you don't shoot is the most powerful. And I think having that litigation complaint bullet, staying in the gun and never being fired, but being able to use that to compel the parties to reach a resolution that everyone can live with is a powerful tool.
Sorry.
I just want to comment and add to that. So I'm not sure, and many judges require mediation today. I think the problem is the parties are using it as a crutch too much. And through the years of practice, I've always made it a point to reach out and have conversations with the opposing counsel and see if I can resolve it on my own. And I don't think it's an act of weakness. I think you need to have those conversations and form some sort of relationship, even though it's a contentious profession. At the end of the day, I'm a mediator. I mediate a lot of cases for other parties, and I'm shocked how many times people come to my mediation and they haven't had a single conversation about settlement before they walked in the door, not one. So I think practitioners are relying on it too much. I think if we need to step back as practitioners and just try to work on our own as best we can before we get to there.
Sure. Yeah. Jim, did you have something?
There is a reality, I think, that we have to confront as people in this profession with financial obligations to our firms, to our families, that, it's hard sometimes for some lawyers who maybe don't get as many referrals or as much business to give up the billable hours that are associated with litigation. And there are some people, quite frankly, that are pretty notorious for churning things longer than they need to be churned. And that responsibility ultimately lies with the bar, not with the bench, not with the clients. It's really our responsibility to police ourselves in certain respects to make sure that if somebody is doing that, that they pay a price at the end of the case with a big L next to their name.
All right, thank you. So, Ryan, back to you. From a strategic standpoint, do you agree that requesting mediation can be perceived as a sign of weakness? And how, if all, does that perception factor into your litigation strategy?
I mean, I think it can be perceived by attorneys that don't practice a lot of business litigation, but I think a seasoned business litigator will always see that as you representing your client to let them solve their own problems in a way where they can, like I said earlier, write the end of their story, and you're not letting either a jury or a judge determine the fate of whether you're paying or receiving money. But along the way, they're going to have distractions from their business, pay for all of the fees, the experts, the transcripts, and everything of that like. I almost view being the first person to request mediation as being a show of strength, and that you're comfortable in the facts, you know the law, and you still want to come to a resolution with the parties because you have the facts and the law to support coming to a compromise.
Does anyone on this side, do they agree with that? And then also, do they ever smell blood in the water when a party immediately requests mediation?
Look, there are absolutely times when requesting mediation is going to be seen as a sign of weakness, and you've just got to assess the situation in the particular case. If your gun's blazing and you're in the massive round of depositions and discovery and everyone is full throttle and you say, hey, why can't we mediate? There's going to be times when the opposing party is going to take it as weakness, and we just have to use our judgment as to when we do and don't raise that issue.
All right, thank you. So moving on to a professional development of the business lawyer. Only one question on this, but when it comes to developing associates, do you believe the meaningful mentorship is necessary, or do you subscribe to a trial by fire approach? Sara, this is directed towards you.
I love working with younger attorneys. Anybody who parents knows that when you teach something, you learn yourself. You're learning it from a new perspective. You're learning it through their eyes. You're going to learn more. They teach me things. They teach me the new lingo and the new technology. So I'm a big fan of mentoring younger attorneys, even other attorneys that are sometimes my opposing counsel, because it keeps me fresh, frankly.
Team 2.
I think it's going to be hard for anyone to argue that mentoring young lawyers is a bad thing. I think it's necessary. I mean, we all have an obligation as more senior attorneys to supervise the younger associates, but I think mentoring goes beyond that. It is showing them, how do you network? How do you rainmake? How do you deal with the stress of being a lawyer? I think it's taking it more to the human level than just the nuts and bolts of, here's a red line, this is why I did it. I think that's important, but I think mentoring goes beyond that. I've actually had both experiences in my career. I was lucky enough to have Judge Rosen as a mentor while I interned with him, and one of the first and only bankruptcy cases I've handled in my career, I was assigned to the Detroit bankruptcy to represent 2 retiree associations. And that's about as much as throw them in the deep end as it gets. So I definitely see the value in that. But I would have much rather had a mentor along the way on how bankruptcy works and how to handle the media and things like that. So I think it's absolutely critical to have mentorship. And there's even some states that are now allowing apprentices to take the bar exam, and you don't actually have to go to law school. So going more to a mentoring apprentice model is something that I think is becoming more and more useful as opposed to just the traditional law school experience.
Yeah, sure, Jim.
There are many people in my office who will often hear the rant about, on certain days, about how treacherous and how difficult it is to do the job that we do. One of the few joys that I get out of practicing law, and have always gotten out of practicing law, is mentoring young lawyers. I have a shout out to give to Frank Dowd, probably the most talented lawyer out of law school that I've ever worked with in 30 years of practicing law. Huge blessing in my life. I hired out of law school a young woman in 2004 without even looking at her resume. I didn't really want to hire her, but she told me that she had passed the bar 3 weeks after giving birth to her first child. And I thought to myself, well, I studied for that exam night and day for 2.5 months, and I barely passed. And this woman, she was in labor and taking her bar review. I went to my brother and I said, I know we don't have the money, I know we don't have the work for her, but we've got to get this person in our firm. She went on to become the longest serving corporation counsel in the history of Wayne County. She is now the general counsel for the Kresge Foundation, $1 billion charitable foundation in the city of Detroit. And 18 years after I hired her out of law school, I married her sister, my wife, right there, Rana. So mentoring, I mean, I could cite story after story, people who have gone on to do great things in their careers. One of the most rewarding things for me that sustained me and has kept me in this business for 30 years has been the opportunity to mentor younger lawyers. It's the best part of what I do.
Can I just add, yes, we all need to mentor younger attorneys, but with respect to the question, trial by fire, sometimes you got to throw the younger lawyers in there. Sometimes the younger lawyers come to me and they say, I'm not ready, I'm nervous, and you got to say, get in there, give it a shot, right? Get in there, learn, that's how you learn. So it's a little bit of both.
Thank you. So, Joe, if you seek an extension of time to answer while intending to file a motion to dismiss in lieu of an answer, do you believe that you have an obligation to disclose that intention to opposing counsel?
That's a great question, Noah. And I'd say there's certainly no obligation to disclose your strategy and how you're going to defend your client's interests. But some important background about me. I'm originally from the Philadelphia area. I'm a big Eagles fan, of course. And the play that the Philadelphia Eagles made famous over these past few years is a play known as the tush push, or as true scholars of the game call it, the brotherly shove. Now, what I love about this play is that when they're running it, everyone knows what's coming. There's no nuance, there's no subtlety. It's just line up, hike the ball to Jalen Hurts, get that first down, get that touchdown. Although, not so much this past season, let's not talk about that. I say, when it comes to motions to dismiss, take the brotherly shove strategy. And you don't even need to be able to squat 600 pounds like Jalen Hurts to do it. If you've got a motion to dismiss that you really believe in, be very upfront with the other side that this is what I'm going to be doing out of the gate. It can really help leverage your position, and maybe you can negotiate a favorable settlement out of the gate without having to go through the rigmarole of filing, briefing, and arguing motion. So at the end of the day, I think no need to be coy, and subtlety can often be overrated.
That's a great point, Joe. Any response from the other side?
I really don't think there's an obligation. I appreciate what you're saying, but typically when I'm asking for an extension, I think the person that I'm asking may decide whether or not they're going to give me an extension if I'm filing a motion for summary. I typically ask if I can have an extension for my first response to pleadings. If they know their case and they know their weaknesses, they know there's a possibility there's going to be a motion. So I'll ask for an extension for my first response to pleadings. I may change my mind and not file the motion. I may just file the answer and then file the motion after just to take the time pressure off. But I just asked for an extension for my first response to pleadings, and then my client and I can make the decision what we're going to do from there.
Can I make just one more comment on that?
Please do.
My biggest pet peeve is when you ask for an extension and they say only if you file an appearance. There's often times where you're still in the process of getting the engagement done, getting the all-important retainer in, and other things that you need to do before you can actually make an appearance in a case. Because once that goes in, you're not out until the judge says you're out. So I think just giving the courtesy of an extension, being a human, and knowing that that will come back for you when you need it, I think is important.
All right.
The only counter to that, I understand it. I have those conversations, and I do ask, are you filing an appearance? If the person said, I'm getting engaged, I will say, no problem. Let me know when you're engaged. And the only reason why is some opposing counsels, they disappear. And so you want to make sure that this thing's moving along. It's not trying to be disingenuous, but I'm courteous enough to say, look, when you get engaged, call me, and then let's work it, but you have the extension until you get it worked out.
All great points around. All right. Moving on towards something that might bother or be in favor of a lot of attorneys. Jim, should objections and depositions be limited to privilege and form? And do you think there should never be any form of a speaking objection?
No, I don't. There are situations where, and it's happened to me recently, where a younger lawyer was cutting off my client before my client could answer the question. And the reason wasn't because she was anxious or anything else of that nature. It was because the lawyer didn't like the answer that was coming out of my client's mouth. There are situations where another lawyer will insult a witness, and those sorts of objections need to be made plainly. That further conduct like that is going to result in a call to the judge or escalating the issue. But those are typically done, and more than just object to form or object to privilege.
Does anyone on Team 2 have any feelings about speaking objections?
I'd love to jump in on that one. I will say, for those of you who have not reviewed the jurisprudence that is out there on speaking objections, fire up Westlaw or Lexis when you get home. And also, if we have any law students still in the crowd, might be a good topic for a law review note. Dozens of people would read it, that's like a New York Times bestseller as far as law review notes go. But I definitely agree that for the most part, you need to be concise, limit it to form and privilege, but situations definitely arise when that's just not going to cut it. If you've got somebody being rude, things of that nature, it not only it makes practical sense to approach it that way, but courts even recognize that. And one situation where courts are going to give people more leeway to maybe make a more verbose objection is when maybe the examiner's questioning isn't clear. And what I think it really comes down to is the objection clarifying something, making it easier for everyone down the road, or is it really just an instance of the person trying to coach their witness? If a person is being examined about incomplete records, or maybe it's not clear which of several business entities they're being examined about, I think that's an appropriate time to jump in and try and get some clarity, as opposed to just having it proceed, and then when you're up arguing summary judgment, you don't know what anyone was talking about.
All right, thank you. So Ryan, this one hits close to home as of recent, but we talked about mediation requirements and whether you should be required to attend mediation through the court. For meet and confer requirements, they're supposed to reduce motion practice, but haven't they largely become a procedural box checking exercise?
Unfortunately, I think they have become that. There are some of the business court judges that require more, and I think that is something that should be encouraged. If you have a strong motion and grounds for it, don't be afraid to share it with the other side, similar to what Joe said, is do the tush push. Say, this is my motion, this is why I'm filing it, these are the facts, and I suggest you concur. And if you don't, then we'll let the judge decide. And I think that's very important. For dispositive motions, most people aren't going to say, okay, I'll dismiss my case. But you may be able to narrow the case. There may be some claims that don't have the support and someone just used a boilerplate complaint that you can narrow down those issues. So I do think the meet and confer is important, and it's something that, again, as a service profession, not only communicating with our clients, but communicating with opposing counsel. Don't just send an email at 3:58 that says, if I don't get concurrence, I'll be filing this at 4:30. That doesn't do what's intended to do. Actually have a conversation. Pick up the phone and have a conversation. Not only will that potentially make the motion unnecessary, but you're going to continue to develop a relationship with someone who you're likely going to be living with for an extended period of time. So try to make that experience as unmiserable as possible.
You know, I think Ryan makes a great point about how much information needs to be in your email or phone call regarding concurrence. And I want to ask Team Noah your position on this.
In a complex business case, a motion doesn't come out of nowhere. You've probably had discussions. You probably know what the other side's position is. If you've done your job, you know if this is something that they would just concur in. That said, it drives me absolutely bonkers when I've had multiple conversations about it. I know the other side would never agree. I know their position is, for example, I'm not going to give you the documents unless I have a court order, and then I file the motion, I seek the concurrence in an email, and they say they didn't ask me for enough concurrence. They didn't give me enough time. It's like I had 3 weeks of discussion with you on this. So I think it has become a procedural checkbox that is being used not towards actually what it was supposed to be, which is not clog the court's dockets with a bunch of nonsense discovery motions, but as just another way to complain.
Thank you. And I think this is going to be our last question based on the time. But Jim, under what circumstances should you seek monetary sanctions against attorney or party?
Well, the first circumstances where you've discussed it with your client, what are the pros, what are the cons, and you're given a direct instruction from your client. There's not much wiggle room there. But I think in 30 years I've moved 3 times, twice in one case, and it's typically in a situation where somebody's been particularly egregious in their conduct, and you think that they need to hear it reflected back exactly how egregious you think the conduct has been, and allow the judge some insight into what's happening in the case.
Without naming names, what specifically would give rise to that?
Withholding information
Unless you want.
intentionally that is subject to discovery that was clearly requested in discovery. That goes, I think, beyond the pale that most of us would tolerate, in particular obnoxious behavior from someone who's clearly more interested in gaining advantage with that conduct than in seeking justice in their cause.
All right, anyone from Team 2, they have any opinions about when to seek sanctions?
I don't consider it a good idea usually. If it's big money and we're at a point, certainly if it's the end of the case and it's big money, yeah, I have sought them, but not very often. Attorneys seek sanctions against each other during a case. It just makes a case harder to do. It makes it more expensive, and it doesn't usually serve the clients unless there's something really egregious.
I think also in a lot of motions, it's just become part of the add-on at the end. And I think people need to think strongly about asking for sanctions, especially if it's against the other attorney. It's a small community. We have relatively long careers generally. So just be mindful of what you're asking for and why you're asking for it. But I think it has become somewhat of a just check the box and sanctions for having to file this motion. I think motions are what we do as attorneys, and just because someone files a motion doesn't mean they should be subject to sanctions.
Thank you. Ryan, unless anyone else has anything else to say on Team Noah, that will conclude our segment.
Thank you all.
Thank you to our presenters. Our next round begins shortly.